She openly admitted she violated the rules, but what truly changed the outcome was the attitude she showed afterward. Leaving the county without permission was already a serious mistake, but telling the judge she did not understand why it mattered only made the situation far worse. Stay until the end, because one careless explanation inside the courtroom quickly transformed a possible second chance into real prison time. The judge listened closely, and the reaction in court shifted the entire direction of the case within moments. What could have ended with leniency suddenly became a harsh reminder that words and attitude can carry just as much weight as the violation itself.
Calling 2023 CR 7787, State of Texas versus Anna Marie De La Rosa. Can I have parties announced for the record for the state?
State.
Defense.
Ray Lopez for the defense.
All right. And are you Miss De La Rosa?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Anna Marie De La Rosa who was placed on deferred adjudication in 2023 CR 7787 for the offense of burglary of a building with intent to commit theft on April 30th, 2024 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
Your Honor, the state wishes to proceed on violation of condition number 6. On or about the 10th day of July 2024, the defendant Anna Marie De La Rosa departed Bexar County without the written permission of the court and or supervision officer in violation of condition number 6.
How do you plead to that? True or not true?
True.
We waive and abandon all of this, Your Honor.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 6, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 6?
Yes.
Court will find violation of condition number 6 true. Is there a proposed agreement?
There is, Your Honor, it is for the state's motion, enter an adjudication of guilt against the defendant, revoke her community supervision, and sentence her to 232 days in the Bexar County Jail under Texas Penal Code 1244A.
All right, so why would I follow this agreement? Because I'm assuming that's a judgment satisfied.
It is, Your Honor.
All right, why would I do that?
Your Honor, she's contesting the charges that she picked up in Medina County. She does admit, though, that she left the county without permission and remorseful for that. And is looking to put this matter behind her.
Oh, I'm not, just so everybody understands, I'm not considering anything else on the motion. I'm just considering violation of condition number 6. Has she done anything on probation? Has she completed anything? You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Anna Marie De La Rosa.
All right, what have you done on probation?
I reported to probation. I've also been looking for work, like as said on my probation. I had work in line, but considering that I left.
Why did you leave the county?
I had to go and pick up my sister-in-law from where she was at because
This is the moment where the explanation begins to fall apart. She openly admitted that she left the county without permission and claimed it happened because a family member needed transportation. She then told the judge that she did not believe it was a serious issue. That response immediately changed the atmosphere inside the courtroom and revealed how casually the court orders were being treated. What may have sounded like a simple excuse quickly became a damaging statement that raised even more concern about accountability and responsibility in front of the judge.
At that time, and she just needed a ride, so I went to go and get her. So I mean, I didn't see where there was a problem or an issue at that moment in time because it was just going and picking her up, and that was I didn't see that there was a problem.
Did you start on your parenting classes?
No, I have there was a parenting class that was in line for there.
No, my question is, did you start your parenting classes?
No, ma'am, I didn't.
All right.
But the reentry program does have those parenting classes, and so I just had to wait to get into that
Were
program.
you in felony drug court?
No, they said they denied me because I don't have no drug issues since 2017. My case wasn't related to drug issues.
And
I didn't
you're
come
not
in on no drug
employed?
charges or anything, so they, drug court denied me because I have no drug.
Have you been
charges.
employed since April 30th, 2024?
Have I been employed?
Yes, since you've been on probation, have you ever had employment?
Well, my probation officer was supposed to check in with you because, I have a history of working, through a providing agency. But because you took that away from me,
Watch closely as the situation becomes even more tense in front of Judge Boyd. When she was asked a direct question about whether she had found a job, she avoided giving a clear answer and instead shifted the focus toward the probation officer and the drug court program. That response immediately stood out in the courtroom because the judge was looking for responsibility and honesty instead of excuses. The moment she began placing blame on others, it appeared to confirm deeper concerns about accountability and whether she was truly taking the court's orders seriously at all.
Allow people to work as home health care providers when you're on probation for a felony. Everybody knows that. So my question is, have you had employment since April 30th, 2024?
no, so I was looking for.
All right, so that's a no. Did you report to probation
I
since
did say-
April
I
30th of
did tell,
2024?
yes, ma'am, I did. And I was, also calling the hotline like it was told to do. I was doing my conditions as followed. Yes, I was.
Any other questions?
And I also called my probation officer to let her know where I was at. I tried contacting her several times and stuff. So, I mean, I did everything that I was supposed to do. I do have job lines followed as well when I get out of here too.
But you haven't had an employment since April 30th, 2024. Any questions?
Ms. De La Rosa, did you complete your TAP evaluation?
Yes. Yes, ma'am, everything was done.
When do you recall doing that?
When I was incarcerated in Bexar County. It was a top evaluation and then it was followed through drug court, which they denied me because like I said, they said because I don't have no drug history, there was no reason for me, for them allowing me to take that course.
And then, so you were released from custody in June of 2024, does that sound right?
Yes, ma'am.
Okay, and then you were ordered to submit to drug testing in July of 2024. Do you recall that?
For the phone.
Yes.
Yes, and I was calling every day like I was told up until the time that I got placed into Medina County.
Okay.
And then I was there for 4.5 months.
So are you aware that your probation officer stated that you failed to submit to drug testing on July 12th, 19th, and 26th of 2024?
Because I was already incarcerated.
You were already incarcerated in July. And then are you aware that your probation officer is alleging that you struggled with calling the UA hotline as you were instructed to do?
If I wasn't incarcerated, how was I able to call the hotline?
So when were you incarcerated?
July 12th, 2024.
But before that, are you aware of any that your probation officer is alleging that you were having trouble, calling in on the UA hotline?
Because I was already incarcerated in July.
Before your incarceration?
There was no, I was calling every day. There shouldn't have been a reason why.
All right, any questions? Probation,
Yes, good.
what is probation's recommendation?
Judge, the court summary indicates they want revocation.
All right. Any objection to the court reviewing the court summary?
No.
Thank you. All right, thank you. The court is going to grant the motion, find you guilty. The court will revoke. The court will sentence you to 14 months. And
The opportunity for leniency officially disappeared in that moment. She may have been expecting another chance, but Judge Boyd decided to fully revoke her probation and ordered 14 months inside a state jail facility. The courtroom atmosphere changed immediately as the consequences became very real. This became a powerful example of how ignoring court orders and showing disrespect toward the legal process can quickly turn a manageable situation into serious prison time with lasting consequences.
with Veronica Garza for 1803 Macaulay, McCauley, San Antonio, Texas 78224. And no contact with Jose Gutierrez. I'm sorry, with Grace Rocha and Jose Gutierrez. And Raquel Puente. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
Anna Marie DeLoa was given a clear opportunity to avoid serious prison time with a plea agreement that could have resulted in just over 200 days behind bars. All she needed to do was convince the court that she respected the conditions of probation and understood the importance of following the rules. Instead, she minimized her actions, made excuses, and appeared to downplay the seriousness of violating court orders. That decision completely changed the direction of the case. Judge Boyd rejected the lighter outcome and imposed 14 months inside a state jail facility, turning what could have been a short sentence into a major consequence. This became a strong reminder that attitude and accountability inside a courtroom can heavily influence the final outcome of a case. Many viewers may now wonder whether the punishment was too severe for leaving the county, or whether the sentence was exactly the wake-up call she needed. Share your thoughts below and subscribe for more courtroom breakdowns and legal commentary.